So what does it mean to be admitted to the United States? What does it mean to be seeking admission? What does it mean to be an applicant for admission to the United States? Is that everyone, whoever enters? Is that just a limited number of people? Is it limited by time, place, location, etc.? We're going to talk about that today because there has been a whole kerfuffle in immigration law over this tiny little oversight, this drafting error, not even a drafting error, just poor drafting of the nation's immigration laws. Okay, the words we use are important. As my dad would say, words have meaning. Words mean things. They are significant. And so we're going to dive into that a little bit today over one of the recent controversies, matter of Yajur Hurtado, which was recently ruled unlawful by a district court in the Ninth Circuit, the Central District of California. We're going to talk about that, what it is, how it affects you, how it affects everything in the world today. Let's get started. Now, as always, we're sponsored by Prima.Law. That's immigration case management. We are a legal case management platform specially designed with additional features for immigration attorneys, so we can really bring out the best in immigration attorneys, helping them serve their clients better by accepting online payments, using a client portal, sharing that checklist directly so your clients can share those secure documents in a very secure manner. Find a free 15-day trial at Prima.Law. That's for immigration attorneys and immigration professionals. Let's start the show. So let's begin the show today by talking about the word. And the word is the word of the day. And the word of the day is admission. What is an admission in immigration law? Okay, it's a word that we use all over the place. It's used in the regulations, it's used in the statutes, it's used in policy memos, it's used in practice manuals, guides, everything, right? Even the forms themselves, we're constantly using the word admission. So this sometimes is synonymous with being admitted or being inspected and admitted to the United States. So what counts as being admitted? Because the use of this word is very important because it allows certain things and disallows other things. Somebody who's lawfully admitted to the United States, even if they overstay their visa, if you're lawfully admitted, well, then you have an option, perhaps, depending on your situation, of adjusting your status in the United States, which is another term of art, right? We couldn't just say green card win, right? We got to say, no, adjustment of status. Well, anyways, back to the word admission or being admitted to the United States. There's certain privileges that come along with that. And there's certain classifications. For example, if we have an undocumented immigrant and they're encountered by ICE one way or another, do they get a bond or not? Do they have an opportunity to ask for a bond? These are all things that can depend on whether this person was admitted, whether they're seeking admission, or whether they're no longer seeking admission, but they're already here. So the use of the word admission is terribly defined. It's incredibly confusing because even if you're someone who's trying to understand immigration law and you've got to go and read the statutes, it'll say, well, you get this if you're admitted. You get this as an admission. You can be admitted this way or that way or this way or that way. And because there's two main ways to get visas or green cards, right? You're either applying in the United States for some sort of immigration benefit or overseas in your home country or country of perpetual residence or continuous residence, or if you get an appointment at the U.S. consulate in your home country, you might be approved for a visa, green card, residency status over there. So is it the same thing to be admitted if you get your green card in the United States because you're already here, or if you get it over at a U.S. consulate? Okay, it's not always the same thing. Why is it not always the same thing? Because whoever writes our statutes are idiots. They don't have the benefit of experience. They don't have the benefit of a clear understanding of how it is and how it even should be. That's what we get, I guess. I mean, I guess we voted people in and they were passed years ago. It's not something recent. It's not like a recent development that all of a sudden Congress became a bunch of incompetent persons who do not know how to communicate their ideas clearly. But I can tell you this much. we have entire classes in law school about legal writing and the good principles of legal writing. One of the good principles of legal writing is that it's easy to understand at something like a 5th or an 8th grade level. Anybody who reads it should be able to understand from just reading it, that we shouldn't have to go back and refer to 35 other statutes or refer to definitions in different statutes in order to understand what we're reading in front of us right there. And that's part of the problem. In fact, I remember seeing, I don't remember who it was, but there was a member of Congress and a reporter was asking, hey, well, what do you think about, I don't know if it was the DACA statute, not statute, because that wasn't a statute. I don't know what you think about the green card process or green card renewals or citizenship or this or that. It was something that had to do with immigration law. And he was an older gentleman and he admitted, look, I sit down to read this and I see it says this, as in section 245. And then I have to go look at section 245. And then in section 245, it says, yeah, we're doing it this way, as is shown in 101A3. So then I got to go over to 101A3 and try and figure out what that was. And by the time I'm done following all those ladders, all those links in the chain of trying to understand this, I can't even remember what I was reading at in the beginning. And so it's a circular thing. And so the dark secret is that many of the representatives in the House of Representatives and many of those in the Senate, and certainly the president himself, does not read all of these things. It's very complicated. So what they do is they rely on think tanks, they rely on nonprofits, they rely on people they term as experts, or they rely on their political appointees or people who pay them money, right? Special interest groups, right? So you might have a union that is the one drafting the immigration laws, and they're not all experts in immigration either. They're more into labor stuff, right? But they end up drafting these things in a way that is not very easy to understand. And this is an excellent example of that. So what happens? Recently, we have a case where an individual is picked up by immigration. They say, you know what? You had TPS is canceled. So now you're coming with us. And he says, great, I would like a bond hearing, please. And the judge in that case says, I no longer have jurisdiction to give you a bond hearing because the head of DHS, it's either the head of DHS or the attorney general in this case, they've decided that they're going to expand mandatory detention, right? So ostensibly there is a section of law. It's found in 8 U.S.C. 1225. And in that section, there's a section where it says all this stuff about arriving aliens. And then there is a subsection of that where it talks about, now the secretary can actually enforce this against all aliens if he wants to. It says something like that. It doesn't say specifically that, but it's like all aliens described in this section, this can be applied to. And so what the Trump administration did not too very long ago is they said, you know what? We're going to use that section of law and we're going to have DHS secretary say, you know what? We're going to apply mandatory detention essentially to everybody who is in the United States unlawfully. We're classifying all of them as arriving aliens. Okay, now there's two problems up front with that. Just from a strictly legal perspective, there is a whole other section, and that's under INA. Let me find it here. Okay, so INA, Immigration and Nationality Act, Section 235, B2A, is the statute that the administration tried to use to strip the ability to give a bond to immigrants who have been here already. But there's a whole other section, and it's Immigration and Nationality Act. So we abbreviate that INA, Section 236. So just briefly, INA 235 under B2A, that is a section for mandatory detention for applicants for admission pending a decision in removal proceedings. And historically, this was aimed at people at the border or ports of entry. So somebody arriving, literally, are you an arriving alien? Well, were you arriving to the U.S. when you had an interaction with immigration, right? So many people who are crossing the border unlawfully, perhaps, or lawfully, but if they're caught right there near the border, or as the statute says, within 2 years of being here, those are the ones who are classified as arriving aliens or applicants for admission. They're the ones, because they use these two terms, arriving alien and applicants for admission. Now, Section 236 is a section under 236A, subsection A, that is discretionary detention of non-citizens arrested inside the U.S. with immigration judge bond authority and custody redetermination hearings. Okay, so there's two sections of law to deal with the situation of, hey, we have an immigrant here, do they get a bond or no? Well, the question is, are they an applicant for admission? Usually meaning, are they an arriving alien? Are they someone who's just coming to the border and they had an interaction with us and now we're going to do something with them? Or are they someone who's been here for more than 2 years already? So depending on where the individual falls, are they arriving? Well, they're actually mandatory detention for applicants for admission. Are they someone who's been here for more than 2 years? Okay, well, they're under Section 236. The judge has the discretion to give them a bond, and they have the right to a bond hearing and a bond custody, a custody determination, right? So it's a court hearing where you go in and say, Judge, look, I'm not a flight risk. I got a family. I got a business. I own a house. I got cars. I got a job. I got all this stuff that ties me to the community. I got all of it. I'm going to lose it if I don't show up at court. So please let me, I'll pay a bond and then I'll promise to come back to court. So let's talk about matter of Yajuri Hurtado, 29 INN, December 216. This is a BIA case 2025, so just recent. Here is the factual background. The respondent, or the immigrant in this case, crossed the border into the United States without inspection, November 2022, near El Paso, Texas. Okay, so he entered without inspection, meaning he didn't show up to a port of entry and say, hey, I'd like to come in and apply for asylum, please. He snuck across. Okay, so entering without inspection, pretty clear, that's what that means. He applied for and received TPS status, so temporary protected status in 2024. Now, temporary protected status is just what it says. It's a status given to individuals temporarily, usually based on their country conditions. Like things are so bad or dangerous in their home country that the Department of Homeland Security says, hey, we got a crisis here. A lot of people flooding in from this one country, so we're just going to go ahead and give them temporary permits in 18-month increments so that they can at least get a job and live and get food while they're here. The idea is that they then won't be a public burden, right? So this happened with Venezuela. There's all sorts of stuff going on with Venezuela, and there's even more stuff going on right now. Don't even get me started. But he was approved for TPS, and then that status was, according to the note, it expired on April 2nd, 2025. He was then stopped by immigration, and on April 8th of this year, DHS issued a notice to appear. That means they're charging him with immigration violations, and he has to go to immigration court. And they said he was inadmissible for being an alien present in the United States without being admitted or paroled, or arrives in the U.S. at any time or place other than as designated by the Attorney General. Okay, so that's the factual background. The respondent requested a bond hearing, but again, this is 2025, new presidential administration. So even though he requested a bond hearing, the immigration judge determined he had no jurisdiction. So he says, I can't give you a bond hearing because the law doesn't allow me to do that anymore. Why doesn't it allow? Well, because now there's this interpretation of that statute 235, and the president said we got to apply that to everyone. And who's the boss of the immigration judge? The Attorney General of the United States, because they're part of the U.S. Department of Justice. And who's the boss of the Attorney General of the United States? The president, right? So judge says, no, not going to do it. I can't do it. We're not doing that for anyone anymore. And so the applicant appealed. Appealed to whom? To the Board of Immigration Appeals. That's your first stop in most appeals, especially dealing with bond or custody determination. The Board of Immigration Appeals takes a look at the case and says, hey, in fact, we'll read it. We'll read here's the summary of what they say here. Under the plain reading of the INA, the statute 235, we affirm the immigration judge's determination that he did not have authority over the bond request because aliens who are present in the United States without admission are automatically applicants for admission as defined under Section 235B2A of the INA, and must be detained for the duration of their removal proceedings. Okay, so the BIA, for the first time in their history, rule, oh, looks like we had it wrong for 50, 60, 70, that's probably 70 years that this act has now. We've been wrong for 70 years. This actually applies to everyone, not just people who are arriving aliens or applicants for admission. So they're saying everybody who's undocumented is an applicant for admission. Now, that's just dumb because not everybody is applying to be admitted to the United States. And what does it mean to be admitted anyway? It's so convoluted, the definition of this term, right? To give you an example, it's one thing that's changed a lot over the last couple of years, right? So there was a question not too long ago because of a case called Matter of Flores, which in the Sixth Circuit allowed for someone who was granted TPS to count that as an admission to the United States. Think about it like this. You're in the U.S., you don't have any papers. You file an application to apply to have a lawful status in the United States. And so you're thereby admitted to the United States due to your lawful status. Okay? Now, you may not cite this as authority for anything because I'm going through a long example. I'm going to show you why it's all silly. The way that we use the words in immigration law. Admission, admitted, application, things like that. And so for at least the Sixth Circuit, you could do a matter, I believe it was Matter of Flores, or a Flores adjustment of status. If you had TPS, and you got TPS, and you didn't have some other removal order or any other immigration problems, you could then apply for adjustment of status if you had a spouse who is a U.S. citizen, or son or daughter who is over 21 years old could petition for you as well if they're a U.S. citizen. So what happened there? Great. A lot of people who only had a temporary work permit were able to get green cards because at the time in the Sixth Circuit and USCIS recognized that you were an applicant or that you had been admitted due to receiving your TPS status. There was another case where if you would travel while on TPS, if you obtained a travel permit and permission to travel, and then returned to the United States, oh, maybe that was the Flores admission or the Flores adjustment. If you had a permit to travel and then you re-entered the United States lawfully, now all of a sudden you're admitted. You were an applicant for admission and you had that paper, so they admitted you to the United States. Okay, so if you had TPS, you could travel. And then if you had a family member who could petition for you, you could do an adjustment of status here. Because that adjustment requires you to be inspected or admitted, or inspected and admitted to the United States. Well, as policy things happen, I think it was last time, the first Trump presidency, if I'm not mistaken, is when this all sort of went down. They said, well, we don't want them to do that anymore. We don't want to count that as an admission anymore. And I can't remember exactly how it played out, whether it was a court decision or it was a pure policy decision. But all of a sudden, that wouldn't work anymore. Traveling on TPS, coming back, that doesn't work anymore to be counted as an admission. Purely having TPS or being granted TPS does not qualify you as being admitted to the United States. Okay. Even though you're here with authorization and with permission, you are not officially admitted to the club. Okay, so we play with the semantics with the words on that. But now for the first time, the BIA was saying, well, everybody, if they entered unlawfully, is an applicant for admission because even though they haven't asked to be admitted, even though they have not technically been admitted, they are now applicants for admission because of what the president and the attorney general say and what the new policy at DHS is. So that was new and that was challenged, right? That was challenged. And in the Central District of California, we actually had a favorable decision. Let's pull it up here. I wonder if that's in. Right. So what this decision resulted in is many people across the nation, immigrants, undocumented immigrants being detained and denied a bond hearing. because all of a sudden the rule from the Board of Immigration Appeals, which binds the entire country for immigration purposes, unless it's overruled by a particular circuit. And then we had a bunch of attorneys filing habeas corpus petitions, which we've touched about on this channel before. And these habeas corpus petitions is a federal lawsuit that you can file if you believe your client's due process rights are violated and they're being held and they should be released. Okay, and then if you get a successful order in your habeas petition, the federal court will tell the immigration court, hey, mind your business and do your job. Give this person a bond hearing or release them, right? So that happened all over the country. And one of the first cases to have a really nice result on that is found in the Central District of California. It's called Lázaro Maldonado Bautista et al. V. Ernesto Santa Cruz Jr. et al. So essentially what you have is an immigrant or collection of immigrants and their representatives suing everybody who's in charge of detaining their clients, right? So it could be anyone. In federal cases, you can actually just list USA, or you can list by name the secretaries who run the agencies that are violating your client's rights. Okay, so recently, this was November 20th, right? We get this order. This is an in-chambers order granting the petitioner's motion for partial summary judgment and denying the request to enter final judgment. And essentially what this says is that case by the Board of Immigration Appeals is legally incorrect and unlawful. And it's because why would this whole other section of law exist to deal with people who've been here for more than 2 years? Why would it exist at all if Congress wanted to just throw everybody into mandatory detention? It wouldn't exist. It's a surplusage or a surplus argument. Every statute under rules of statutory construction, every word, phrase, section, if it was drafted and is part of the statute, has to be given an interpretation that gives it meaning. And that wouldn't make the whole rest of the statute that was created meaningless. Okay, that Congress doesn't usually do that on purpose. They won't pass a law with a bunch of irrelevant words that are not supposed to do anything. No, when they pass a statute, it's because it's been reviewed, it's been negotiated, it's been debated. It has a purpose. So to give Section 235 the meaning that, hey, everybody, it really just falls in here, when there's a whole other Section 236, wouldn't make any sense. So from the judge's order, we can just read about that policy change that happened in July 8th, 2025. The Department of Homeland Security instituted a notice titled Interim Guidance Regarding Detention Authority for Applicants for Admission. Right? This was their policy memorandum that went out that communicated DHS's choice in coordination with the Department of Justice to revisit its legal position on detention and release authorities. They determined all on their very own that Section 235 lets them do whatever they want. Well, would serve as the applicable immigration detention authority rather than Section 236 for all applicants for admission. In other words, the change in policy requires ICE employees to consider anyone arrested in the United States and charged with being inadmissible as an applicant for admission under 8 U.S.C. 1225 B2A. Okay, and they are subject to mandatory detention with some circumstances for those applying for asylum, etc. So that was wrong. And the judge here pointed out quite clearly, and other courts are starting to do the same, especially in the context of these habeas corpus petitions. Now, the attorneys in this case, of course, they were filing based on their list of specific clients that they had. But they did a really smart thing, and they went ahead and amended their complaint to make it a class action. And a class action, if you're an attorney, you have a general idea of what this is, or if you like John Grisham novels, you know what this is about. A class action is where you have a group that essentially represents a larger class of people. And you're saying, hey, there's actually all these other people, so many that it would be inefficient for the court to deal with each of their cases on an individual basis. Judge, certify the fact that we do have a class like this, and let's let everybody in, and let's let everybody take advantage of our hard work and benefit from it, because all of their rights are violated and they're all in the same spot as these clients are. Okay, so as part of starting a class action, you need class certification. Class was certified. A nationwide class was certified, which now is needed, because if we talked about before, I believe it was in Trump v. Casas, there's really no more nationwide injunctions from district courts. And that's what this court is. It's the Central District of California. And now, because we know that we can't really get nationwide injunctions from one district, you can do a nationwide class action. So potentially, anybody who is scooped up who has been here already that was not an applicant for admission or an arriving alien may be able to benefit from the goings on in this case. So in that case, in the Central District of California, the judge granted partial summary judgment. Essentially, yeah, it's obvious the government's wrong on this. And so for the named plaintiffs or the people who need relief immediately, I'm granting summary judgment to them. She withheld on complete summary judgment because it is a class action and the class isn't fully defined yet. And there's other motions pending having to do with the class. So it wasn't appropriate for her to do that. I would like to point out, though, that the judge in this case is a little bit of a historical figure. So her name is Judge Sunshine Sykes of the Central District of California. Judge, when I saw that name, I was like, wow, that's an interesting name, Judge Sunshine Sykes. She's a member of the Navajo Nation and is the first member of the Navajo Nation to serve as a federal district judge in California. So she's a historical figure as well. So that's pretty neat. And just to touch on the class action case as well, I think it's important to point out the following. When we look at the order that granted nationwide class certification, they define, what class is included in that. And the class that was approved is this one. It says bond eligible class. So it includes all non-citizens in the United States without lawful status who, 1, have entered or will enter the United States without inspection, 2, were not or will not be apprehended upon arrival, and 3, are not or will not be subject to detention under 8 U.S.C. 1226C, 1225B, 1, or 1231 at the time the Department of Homeland Security makes an initial custody determination. So what the plaintiffs did here is they said, you know what, we can't get a nationwide injunction. Those don't work anymore. Thank you, Trump v. Casas. So what we need to do instead is we're just going to make this a class action. And who's included? Anyone who has entered, who will enter, anyone who wasn't inspected or won't be inspected, and was not apprehended or will not be apprehended. So we're sort of stretching into the future to cover those people who maybe as of the date of this order hadn't entered yet, because these cases, as they may drag on, could take years. You might have someone in a situation where this was decided today and they enter tomorrow, and then they would not be able to be included in the class because they were not part of the class at the time it was decided. So we're sort of reaching into the future for this, which is a kind of a neat thing as well. Now, there are some times in the practice of law, so if you're an attorney listening, right, where you say, you know what, I'm only going to handle these types of cases. I really want to specialize on this one particular thing. One of the gifts, I guess, of the overzealous enforcement of the Trump administration is we do start to get to flex our muscles a little bit in federal court. A lot of times immigration attorneys might be limited to petitions or employment petitions, family petitions, waivers, things like that, maybe a consular practice. But with so much of this happening, it really does make sense to make sure that you're admitted to the federal district court where you live. Now, just as a matter of practice, when I was admitted to the bar in the state of Michigan, I got admitted at the federal district court as well. Didn't know if I would ever need it. Hoped someday it would come in handy. And I was admitted there. And then later in the Eastern District and later in other places, in other federal cases that we've taken. So that would be, I think, step one. If I'm going to give advice to anyone on what they should be doing in their practice right now, because of all of these things, it's going to be very helpful for you and for your clients if you're able to file a habeas petition. Now, with federal court, for those of you who've never touched it, it's mostly online. Like all of that filing, all of that case initiation, you can do that online. All the fees, you can pay that online. You don't have to drive down to the courthouse in order to file that case. And unlike immigration court, federal district court's a real court. So it even feels good to practice there. So, if you've thought about maybe getting admitted, I saw a couple posts from some other immigration attorneys here in Michigan where it's like, yeah, I finally did it. I got admitted in the Eastern District so I can file these habeas petitions. Go for it. You can join our Facebook group. We have a Facebook group called Federal Court Immigration Lawyers, and it's been growing by leaps and bounds. I'll invite you to it as well. Go ahead and search Federal Court Immigration Lawyers on the Facebook, and we can go ahead and approve your membership as well. So you can start seeing some of the success that we're having in federal court. You can see colleagues of yours all across the nation who are getting together and sharing information, sharing strategies, techniques to use. Hey, I'm in this situation. I've never done it before. What can I do? And you see experts jump in and be like, hey, you could look at this, look at this, look at this, which is really nice. It's a really nice collegial atmosphere. It's a safe place to talk about things like that. So yeah, I encourage you to join that, share information. People upload samples and templates, things like that there, sharing trends that we're seeing in decisions and things like that. So that's going to be an important resource for you as well. So yeah, go ahead and apply to get admitted to your district court, to your federal district court. Figure out, run through a sample case and figure out how to get all these things filed online. And when you have a client who's been here for more than 2 years and they get detained and they're not otherwise subject to mandatory detention for a criminal record or something like that, you can go ahead and file a habeas petition for them. And habeas petitions typically move faster. What we're seeing is you can ask for relief within 72 hours. You can ask for relief sooner. You can ask for all sorts of different things. You can ask for preliminary injunction. You can ask that as part of the habeas petition, the government's enjoined or forbidden from transferring them out of the district or out of the state or further away from home like they will do, right? We've seen cases where someone gets detained and it's, maybe 45 minutes from home. And next thing you know, they're being transferred to Minnesota or to Alabama or to Alligator Alcatraz. And you don't want that to happen. That's unfair. And they do it. It's a mean-spirited thing that they do. And they try and, by hook or by crook to get your client out of the country and deny them the due process that they're entitled to. So as part of your habeas petition, you can request that too. There's all sorts of helpful hints, information that's being shared in that Facebook group right now. So I encourage you to go take a look, join, and join in the fun. A couple other updates happening as well. As we know, there was a shooting in Washington, D.C. It was perpetrated by a beneficiary of an Afghani refugee petition. So that's unfortunate. Apparently he was radicalized here in the United States, not in Afghanistan. Well, anyways, as a result of that, the president and the DHS secretary are vowing to try and implement another travel ban. And sometimes these things work. Last time, if you'll remember, a travel ban was successful for a while. It was challenged in court significantly. But there was a period of time where travel from certain countries were eliminated. So there's 19 countries that they're going to review those who received green cards recently as well. So if you received a green card and you were from Afghanistan, Burma, Chad, Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela, well, your case is going to get allegedly reviewed again. I don't know if it's going to be an actual person or if it's going to be an AI or if they're just going to try and do some other strange nonsense. But apparently they want to review the information in the applications to see if there's any other dangerous individuals out there. And I mean, we all know that in an immigration application, there's already the questions. Hey, are you a terrorist? Did you ever support this? Did you ever do that? No. And nobody admits it either. If they were, it's part of the application. So I don't know how that's going to change or how that's going to play out, and neither do they, right? That is still something that's going to happen. They're looking at another travel ban. There's a lot of bluster out there right now just because of the whole political situation. And, well, that's just the way life is sometimes. And to those same 19 countries, USCIS leadership just rolled out guidance, which is effective November 27th, authorizing officers to treat relevant country-specific factors as significant negative discretionary factors in any immigration benefit request. Oh, you're from this country? Well, in response to the shooting in D.C. as well, they're saying we're putting a pause on all asylum applications. So they're not going to decide any new asylum applications for a while. I don't know what the asylum office is going to do, because there are asylum offices throughout the country where their job is to make decisions on this. Hopefully they're still going to be doing the interviews, get the work done, but they're going to be prevented from even giving a decision. A review of green card holders, we already talked about that, from 19 mostly Muslim and African majority countries. And yeah, indefinite pause on visas for Afghans. So that's all in response to that shoot. So if you're an immigration attorney or an immigration professional and you have clients and you've got a lot of cases you got to manage, look at Prima.Law, Prima.Law. www.Prima.Law is case management software for immigration attorneys, because we built in a bunch of special tools just for immigration professionals. We have over 150 predefined checklists, to-do lists, right? You manage your tasks, you manage your notes. We have all the forms there. We have the package assembly tool. The OG package assembly tool just got even better due to some recent updates. We completely redesigned it. Works much faster, more reliably, and better than ever. So you can get all of those applications assembled easily. You can make edits, modifications very easily. So if a client brings in an extra document, you can add it to the package without having to repaginate everything. Okay? So we have a wonderful case management board. It is a smart table where you can easily see and filter and group your cases. So if you need to give attention to the I-130s, or if you need to give attention to any of the other cases, you can filter through and find them easily. Okay? Find a free 15-day trial at www.Prima.Law. And that's going to do it for our show today. Thank you for joining us. If you found this helpful or enjoyable, please like and subscribe. Share it with your friends. We're trying to build a community of immigration professionals here. And join us on Facebook, Federal Court Immigration Lawyers. Have a great day.